Sreeram also has been, remember, waiting to make his point. Now, Sreeram, when you just look at the simple timeline, December 2016, you have someone as mighty as a Sartaj Aziz on the floor of the Senate saying no evidence against him. Then how do things change in a few months? Have they created evidence?
Well, it reflects the civil-military imbalance in that country and how the court-martial process is a way for the military to assert its supremacy over the civilians. And in an indirect way, I think Sartaj Aziz and the Prime Minister's office were trying to get back at them saying, you know, you arrested this guy 8 months ago and still you have not been able to provide sufficient evidence. So that's in itself a very damning indictment of the whole process that's happened. No legal counsel. He could not access our diplomats. Consular access, of course, is our point. And we know, as others have mentioned, that these court-martial processes are usually meant to do mass executions without any due process. So I think we are on a strong legal wicket as far as this case goes, because not just the improprieties in the procedural side, but also the Pakistani argument is going to be that he's a spy and therefore this falls into national security.
Where is the evidence, Sreeram? That is what India has been asking.
Exactly.
Where is the evidence?
Exactly.
Put out the evidence, speak to us.
Exactly.
Sreeram, jurisdiction perhaps can just be one premise, one alibi that Pakistan might be willing to give. But even will that work?
It's a very common tactic for defendants in big international trials like these to go for jurisdiction. In fact, in 1999, when we downed a Pakistani aircraft in our airspace, they went to the ICJ and we actually argued that they had no jurisdiction. The court had no jurisdiction and the court agreed with us. And so it was a big legal victory for India in that case. And there's another issue the Pakistanis have been grappling with as they're making their strategy. They've been saying India has opted out of international court systems when it comes to disputes with Commonwealth countries. But the counter argument for that will be where human rights of an individual or of a group are severely infringed, as we are claiming,
Chaulia,
there's no way you can use the Commonwealth exception.
The fact is, the nature of this order, the nature and wording of this order of the ICJ is binding, but there is no mechanism to implement it. It's only the credibility of Pakistan that's at stake here. So how do we make sure that Pakistan goes ahead and implements this order when we know that the foreign policy is not being decided by the Foreign Secretary or the Prime Minister? It is being decided in the Army Chief's office.
Parikshit, there's a general weakness of international law, which is non-enforceability, unlike domestic law. So even if the ICJ rules against Pakistan, ultimately, when they claim national security or sovereignty basis, they can always say that, this is an exceptional case and we cannot abide by international and our domestic system. They say they have a dualist system, which means that even if the international court rules against them, they are not bound by it because domestically their assembly has to legislate and their constitution has to approve, and that's only how it will happen, and they have their own Supreme Court as a final court for appeal and so on. So they will try to dodge around this even if they lose the case. But I think we have recourse. I mean, even if they try to avert responsibility after our adverse verdict, we can invoke Article 94 of the UN Charter,
and
which
that is
says
exactly,
UN Security Council, and we can put them on the mat.
And that is exactly what our legal team is at the moment mulling on.
Mr. Chaulia, if I could come to you now, the fact is, if Pakistan doesn't really follow this order, if it tomorrow executes Kulbhushan Jadhav, what will be the consequences for Pakistan?
Well, there are countries that have not abided by ICJ verdicts in the past. So for us, the recourse will be to invoke Article 94 of the UN Charter, go to the UN Security Council and demand sanctions, reprimand, or even military action. I mean, of course, it's one individual's life, but, he also represents the nation. It's an emotional moment for all of us here because Kulbhushan Jadhav is the son of this country. And Harish Salve made the case, using high principle. He evoked justice, evoked fairness.
There was a media channel there from Pakistan, and look at the question that question that asked that why you internationalizing the issue. So yes, Pakistan is rattled. That is the discomfiture of Pakistan. That is out in the open then, Sreeram.
We have hoisted them by their own petard, as the saying goes. We have invoked human rights, which they used to use against us on Kashmir all the time.
Yes.
Justice. And we have also said that bilateral, treaty for extradition and so on and consular access do not apply. We are going multilateral and international. So all these used to be the Pakistani talking points. So in a way, I think we must compliment Narendra Modi, our Prime Minister, for taking this bold initiative, firstly, to go to ICJ. We don't usually do this.
Absolutely.
And so he was convinced about the merits of the case. And secondly, the argument was now the entire international opinion is with us. And we're going to actually go more global with our case. Because earlier we used to be defensive, but now we are proactive and pushing.
Mr. Balochishan, immediately with Pakistan, they spoke for over 1.5 hours, but they didn't give us any convincing answer on why consular access has been denied so far, why despite 16 requests there was no answer. They did not give us any reason for not supplying those court documents or the health certificate. We still don't know who defended Jadhav in that military court, the fate of his appeal, whether he filed one and where did he file it. None of those answers have been answered by that lawyer, that senior counsel of the Pakistani government. Sreeram Chaulia, I would like to come in. Very important, pertinent questions not being answered by the Pakistani lawyer. He kept harping about the 2008 agreement, but no answer on the Vienna Convention.
It was technically weak and pretty shallow. There's no question about it. Harish Salve was, way above, far superior in argumentation and in citation of law and precedent and all that. So I'm pretty confident that we are on the winning side. But I'd like to also briefly withdraw from the whole legalese and look at this as a political issue also, because that's what concerns us. And if you look at it, I see that Jadhav is basically a scapegoat for the failure of the Pakistani state in Balochistan and Karachi.
Absolutely.
They are trying to basically put him forward for domestic public consumption and say the Indians are causing trouble and that's why we have this problem. We have no indigenous issue. So in a way, this whole affair, l'affaire Kulbhushan Jadhav, is to cover up for the fatal structural flaws in the Pakistani body politic, and they are basically, unfortunately, framing an innocent man in order to hoodwink their own people. I hope that rational, objective Pakistanis who saw the case today, the arguments on both sides, will realize this. Ask any neutral observer, international observer, I think they will clearly say that India has won the day. I would also add that there's a locus standi issue here. Look at what kind of state is talking about September 11 attacks, invoking the laws against terrorism and the international obligations against terrorism. This state has been very close to being designated as state sponsor of terrorism by many countries, including the United Nations. And they have the gall and the cheek to come at the highest world court and talk about counter-terrorism and how the Indians are actually fomenting terrorism. So this is like, it's brazen one, and it's also illogical, and I don't think it's going to cut any ice. I want to respond. Sushil raised a very important point about why didn't they completely do a blank out and not even turn up. United States did that against Nicaragua in 1984. They didn't even attend the hearings, and the court ruled against the US. So the point is...
They subjected themselves to the jurisdiction by appearing there.
They did it because of their false sense of nationalism and false notion of equality and parity with India. They would be under tremendous pressure at home saying, Harish Salve made such an eloquent argument and we didn't even turn up. So it's all a political game that they're trying to play to show that we are equals and we are no less than India. And that has been the root of the problem in the subcontinent. They've never adjusted to being a smaller country, and wanting to be equal is the reason why we are in such a big mess.